Here begins tape number 1 in the videotape deposition of Bryan Pagliano in the matter of Judicial Watch Incorporated versus the U.S. Department of State in the U.S. District Court for the District of Columbia. Case number 13-CV-1363. Today's date is June 22nd, 2016. The time on the video monitor is 9:31. The videographer today is Jeremy Deneen, representing Planet Depots. This video deposition is taking place at Planet Depots, 1100 Connecticut Avenue Northwest in Washington, D.C.
Good morning, Mr. Pagliano. I'm Ramona Kotka. I represent Judicial Watch in this lawsuit. Thank you for coming in today. For the record, can you please state your full name?
Bryan Michael Pagliano.
Thank you. Mr. Pagliano, am I pronouncing that correctly?
Uh-huh.
Okay. Thank you. Have you ever been deposed in a lawsuit before, a civil lawsuit?
Objection. Instruct the witness not to answer as being outside the scope.
All right. I'll go over some ground rules with you for the deposition, for purposes of the deposition. As you can see, we have a Madam Court Reporter here who will be transcribing everything we're saying today. So I would just ask that we don't speak over each other. I'll do my best to let you answer every question fully. And I just ask that you, although you may anticipate the question, that you just let me fully finish asking the question that I'm going to ask. Is that fair?
Uh-huh.
Okay. The next instruction would be for any responses to be verbal responses.
Yes.
Okay. Thank you very much. Also, there may be objections that your attorneys or other attorneys in the room may state for the record. Unless your attorney is instructing you not to answer, you must still answer the question, okay?
Yes.
Okay. And finally, you've been sworn in. You understand that your testimony is taken under oath? Is there any reason why you would not be able to truthfully answer the questions being asked today?
Objection. Outside the scope of permissible discovery, the witness is instructed not to answer.
Whether there's any reason he can't answer the questions truthfully?
I am not going to debate that with you. The witness has been instructed not to answer. Ask your next question.
Okay. Mr. Pagliano, are you currently employed, and if so, where?
Objection. Outside the scope of permissible discovery, the witness is instructed not to answer.
Could you mark this as Exhibit 1? Mr. Pagliano, have you reviewed what's been marked as Exhibit 1?
Ms. Kotka, I will represent you. The witness has, because the subpoena was served on us. The witness has reviewed it and understands it and has discussed it with counsel. Okay.
Well, I'll need the witness to answer and to tell me rather than his attorney.
It is outside the scope of permissible discovery. I've given you the information you need. We've accepted it as a service on his behalf, and I've made the representation to you.
Mr. Pagliano, have you seen this document before here today?
Same. Objection. That is outside the scope of discovery. Instruct the witness not to answer.
This is a subpoena for his testimony here today for the discovery being taken. I don't know how that can be outside the scope of discovery. You've instructed your witness not to answer?
What is your next question?
Other than this document, Mr. Pagliano, have you reviewed any other documents in preparation for today's deposition?
Outside the scope of permissible discovery, the witness is instructed not to answer.
I'm asking for purposes of preparing for his deposition that has been granted by the court for purposes of discovery taken in this case if he has reviewed any other documents. I don't see how that's outside of scope of the discovery in this case.
Not here to debate that with you, Ms. Kotka. The witness has been advised and the objection is on record.
For scope, is that right?
Yes.
Okay, Mr. Pagliano, are you following your counsel's advice and not answering the question?
Objection for privilege and numerous other reasons. That's outside the scope of discovery, and he is instructed not to answer the question.
And I'm asking if he's refusing to answer the question. Mr. Pagliano, you may answer the question unless your client...
He's been instructed not to answer, and you can't instruct him otherwise.
Mr. Pagliano, have you reviewed the testimony by either Louis Lucan, Stephen Mull, or Karen Lang in the discovery of this case in preparation for your deposition here today?
Same instruction. Outside the scope of the court's order, he is instructed not to answer. Ms. Kotka, if you have questions that are within the scope, we'd be happy to respond to them.
They are within the scope, and I disagree with you that these are not within the scope. All these questions relate directly to what the witness has done to prepare himself for today's deposition, and that has been specifically granted by Judge Sullivan in this case. That's entirely within the scope of discovery in this case.
Do you have another question?
Mr. Pagliano, other than your attorneys, have you spoken with anybody else in preparation for your deposition here today?
The witness is instructed not to answer. It's outside the scope of discovery.
I'd like to briefly go over your employment history in the past 10 years, starting in chronological order from 2006. Who or where were you employed in 2006, and for how long?
The witness is instructed not to answer. That question is outside the scope.
Okay. When did you begin or start working at the State Department, Mr. Pagliano?
On advice of counsel, I will decline to answer your question in reliance on my rights under the Fifth Amendment to the United States Constitution.
What role did you have in setting up the server that was located in the residence of Secretary Clinton in New York that was connected to her email account with the domain @clintonemail.com?
On advice of counsel, I will decline to answer your question in reliance on my rights under the Fifth Amendment to the United States Constitution.
All right. With respect to the setup of the server, which I will refer to as the Clinton server that was connected for the Secretary Clinton's email with the domain of @clintonemail.com, who else was involved in the technical side in setting up the system?
Objection. Vague.
In 2009.
On advice of counsel, I will decline to answer your question in reliance on my rights under the Fifth Amendment to the United States Constitution.
All right. Who paid for the server?
On advice of counsel, I will decline to answer your question in reliance on my rights under the Fifth Amendment to the United States Constitution.
Who paid for setting up the clintonemail.com system?
On advice of counsel, I will decline to answer your question in reliance on my rights under the Fifth Amendment to the United States Constitution.
In 2009, how many email accounts were associated with the clintonemail.com system?
On advice of counsel, I will decline to answer your question in reliance on my rights under the Fifth Amendment to the United States Constitution.
Do you know Huma Abedin?
On advice of counsel, I will decline to answer your question in reliance on my rights under the Fifth Amendment to the United States Constitution.
In setting up the server and the clintonemail.com system, what discussions did you have with Secretary Clinton as to how the system should be set up and why,
Objection. Assumes facts not in evidence.
if any? You may answer unless you're...
On advice of counsel, I will decline to answer your question in reliance on my rights under the Fifth Amendment to the United States Constitution.
Did you have any discussions, if any, with Cheryl Mills in late 2008, early 2009 about the setup of the server or the clintonemail.com system and its purpose?
Objection. Vague and compound.
You may answer.
On advice of counsel, I will decline to answer your question in reliance on my rights under the Fifth Amendment to the United States Constitution.
As far as you know, why did Secretary Clinton not want to use an official State Department email for her state government business?
Objection. Assumes facts not in evidence.
On advice of counsel, I will decline to answer your question in reliance on my rights under the Fifth Amendment to the United States Constitution.
Do you know Cheryl Mills?
On advice of counsel, I will decline to answer your question in reliance on my rights under the Fifth Amendment to the United States Constitution.
Have you ever seen Cheryl Mills while you were working at the State Department?
On the advice of counsel, I will decline to answer your question in reliance on my rights under the Fifth Amendment to the United States Constitution.
What part of that question raises a basis for the fear of potential prosecution?
Objection. The deponent is directed not to answer. That is outside the scope of discovery.
His discussions with Cheryl Mills, I've asked him questions with respect to his discussions with Cheryl Mills while he was at the State Department with respect to the server, and he's asserting his Fifth Amendment privilege. I'm asking whether he ever met Ms. Mills at the State Department. It's within the scope of discovery, and he has raised his Fifth Amendment privilege. To raise a Fifth Amendment privilege, there must be a reasonable basis for it, and it must be appropriate, not just for the purposes of obstructing the deposition.
Ms. Kotka, I object to your soliloquy there. You have been on notice for many weeks that Mr. Pagliano was going to assert his Fifth Amendment rights. He's doing that. That is his constitutional right, and you have no authority and you have no right to lecture him about it. So, if you have another question, let's hear it.
I did not lecture Mr. Pagliano about it. I was actually speaking with you about it with respect to the appropriateness of raising the privilege. We have not yet seen the scope of the immunity agreement. The only thing that you've pointed in the briefs and in the pleadings that have been filed with the court is the creation and operation of the Clinton server. Nothing else.
Ms. Kotka, I don't know what you're trying to do, but I'm not going to get into a discussion with you about that or anything else. As I told you at the outset, if you have another question for this witness, please ask it.
Well, we'll reserve the right to go back to court and to compel if we deem that it's appropriate. And as for the Fifth Amendment, it's for the courts to decide whether the privilege has been properly asserted.
Do you have another question, Ms. Kotka?
If you know, strike that. When was the last time you spoke with Ms. Mills?
On the advice of counsel, I will decline to answer your question in reliance on my rights under the Fifth Amendment to the United States Constitution.
Did you tell the FBI about your conversations with Ms. Mills in 2014 and 2015 that you had about the server?
Objection.
Objection. That is specifically outside the scope of discovery, sustained by
Same
the judge's
objection.
order.
Same objection by the government.
And the witness is instructed not to answer.
And it's not outside the scope to the extent that during Ms. Mills' deposition, her attorney raised potential privilege with respect to discussions that she had with Mr. Pagliano in either 2014 or 2015. So I think it's appropriate to ask the follow-up question to see whether the privilege was properly asserted.
Well, I appreciate your opinion, Ms. Kotka, but that's inconsistent with the judge's order, which says plaintiff is not entitled to discovery on matters unrelated, and it includes pending FBI or law enforcement investigations. You just asked this witness what, if anything, he might have said to the FBI. It is clearly outside the scope. The witness has been instructed not to answer. Do you have another question?
That is not my opinion. I am just stating for the record the basis for asking the question.
Well, ask your next question.
When did your employment for the State Department begin, Mr. Pagliano?
On the advice of counsel, I will decline to answer your question in reliance on my rights under the Fifth Amendment to the United States Constitution.
During your tenure at the State Department, did you oversee the operation and maintenance of the ClintonEmail.com email system and server?
Objection. Compound.
You may answer.
On advice of counsel, I will decline to answer your question in reliance on my rights under the Fifth Amendment to the United States Constitution.
Who paid you in relation to your work that you did in connection with either setting up or operating the ClintonEmail.com system prior to your employment at the State Department in May 2009?
On advice of counsel, I will decline to answer your question in reliance on my rights under the Fifth Amendment to the United States Constitution.
Do you have any knowledge about staff having raised concerns about Secretary Clinton using the email account with the domain ClintonEmail.com for government business?
On advice of counsel, I will decline to answer your question in reliance on my rights under the Fifth Amendment to the United States Constitution.
Did Secretary Clinton ever raise concerns about preservation of federal records on the ClintonEmail.com system with respect to pending Freedom of Information Act requests or litigation?
Objection. Foundation.
On advice of counsel, I will decline to answer your question in reliance on my rights under the Fifth Amendment to the United States Constitution.
If you know, was the ClintonEmail.com system created to thwart the Freedom of Information Act?
On advice of counsel, I will decline to answer your question in reliance on my rights under the Fifth Amendment to the United States Constitution.
Do you know if the Secretary ever deleted any of her government emails on the Clinton.com email system?
On advice of counsel, I will decline to answer your question in reliance on my rights under the Fifth Amendment to the United States Constitution.
Were you ever asked to access the ClintonEmail.com system and delete any government emails during your tenure at the State Department?
On the advice of counsel, I will decline to answer your question in reliance on my rights under the Fifth Amendment to the United States Constitution.
Since February 2013, have you worked for the Clintons?
Objection. Beyond the scope of authorized discovery.
The witness is instructed not to answer.
On what basis?
Outside the scope of the court's order.
Are you working for the Clintons now?
Objection. Beyond the scope of authorized discovery.
The witness is instructed not to answer. The question is outside the scope of the court's order.
Since 2013, have you had any discussions with Ms. Abedin about the setup of the server?
Objection. Asked and answered.
You may answer.
On advice of counsel, I will decline to answer your question in reliance on my rights under the Fifth Amendment to the United States Constitution.
Since February 2013, have you discussed the setup of the server with any of the representatives of the Clintons?
Objection. Vague.
On advice of counsel, I will decline to answer your question in reliance on my rights under the Fifth Amendment to the United States Constitution.
Who's paying your legal bills for your representation in this action?
Objection. Privileged.
Objection.
And outside the scope of the court's order.
Objection. Outside the scope of permissible discovery.
Are you familiar with the term hot wash?
On the advice of counsel, I will decline to answer your question in reliance on my rights under the Fifth Amendment to the United States Constitution.
Are you familiar with a hot wash being done with respect to the Clinton server?
On the advice of counsel, I will decline to answer your question in reliance on my rights under the Fifth Amendment to the United States Constitution.
That's all we have. Thank you very much for your time.
Thank you.
This ends the deposition of Bryan Pagliano. We are off the record at 10:50.